Hi, Mark. This is Aruni. Can I know if Alexander has joined or he's joining anytime soon?
Hi, this is Mark. Sorry, I was just having a problem clicking my mic. Yeah, Alexander is on his way in now. I was just speaking to him on the phone, so
Right.
he's logging in.
All right.
And then we'll start in a couple of minutes. Is that okay?
Yeah, that's fine. If you can let me know once he's ready.
Okay, did you want to say something first, or did you want me to sort of leap in?
No, I will start first and then.
Okay, fine.
Yes.
Perfect.
All right. So are you going to do the presentation, or you want me to share it?
It's probably best if you share it,
Sure.
and then I'll just do a bit of talking, and then I'll hand over to Alexander at the right time, because he'll be doing most of the talking.
Great.
Hi, Aruni. I think I can see Alexander's name here.
Yeah, I'm here. Yeah.
All right.
All right.
Okay. So then we are good to go. Good afternoon, ladies and gentlemen. My name is Aruni. On behalf of the Education and Training Committee of Ceylon Association of Shipping Agents, I would like to warmly welcome our distinguished panelists, CASA Executive Committee, invitees, and participants from our membership, as well as Sri Lanka Customs officials. Before we begin, I would like to give a quick brief on the housekeeping rules of this virtual session in order to avoid disruptions to its flow. We kindly request all participants to always have their video switched off and mics muted. For this session, only the speakers will have their videos and mics switched on. Of course, questions from the audience is most welcome. And if you have any questions, please type them on the chat box so I can pick these up and address them accordingly. Today, the panel discussion is on switch bills of lading. I think it's a very timely and extremely important topic to our membership. This panel discussion will help you understand what a switch bill of lading is, what are the reasons to ask for a switch BL, in what instances you can use a switch BL, when you can say no to it, and the legitimate reasons why a switch BL is required. Before we move on to the session, let me introduce you to the panelists who will take you through the first session. Mr. Mark Bratman. Let me introduce you to Mr. Mark Bratman. He is a claims director and legal advisor at International Transport Intermediaries Management Company Limited and managers of International Transport Intermediaries Club Limited. He is also a solicitor and joined ITIM in the year 2004. He is also a member of Baltic Exchange and the Law Society. He has special experience in resolving disputes worldwide through negotiation, mediation, arbitration, and litigation. He has written articles on legal issues for transport and insurance-related publications, and also given lectures and presentations for industry bodies such as ICS, BIMCO on contracts, insurance, and agency law, including a two-day BIMCO masterclass on agency. He is also the editor of Claims Review. And our next panelist of the day is Mr. Alexander Sandiford. Mr. Alexander is a partner in Reed Smith's London office. He advises energy and natural resources companies and commodity trading companies. A significant part of his practice is early dispute management and provision of ongoing advice in relation to the performance of long-term, high-value contracts. He also has experience of international arbitrations, including arbitrations under ICC, LMAA, etc. In addition, he advises clients on disputes before the English court. So let me open the floor to Mr. Mark and Mr. Alexander. I think Mr. Mark will take over first, and I'm going to share the presentation.
You have to introduce Mr. Hassan as well.
All right. And our third panelist of the day is Mr. Akhtar Hassan, Director of Customs at Sri Lanka Customs. He has over 34 years experience in conducting capacity building programs for senior and mid-level customs officers on investigations, prosecutions, inquiries, and trade facilitations. Mr. Hassan holds a Master of Law in International Trade from University of Colombo. He is also an attorney at law and widely recognized as an expert in customs law and practice and a well-resourced person. So over to Mr. Mark Brackman.
Hello, hi, thank you for that. I hope everyone can hear me and see me. Right, what we thought we would do is I'm going to speak a little bit at the beginning, and then Alexander Sandiford will go through the slides because he produced them. As you can see, they have Reed Smith on them, and he's the technical expert. So just to go back a little bit to what Aloma was saying before, I'm Mark Brackman. I'm the claims director at ITIC, and ITIC is the International Transport Intermediaries Club. We are an insurer, and our biggest type of insured are ship agents all over the world, and we handle claims for ship agents every day, and we print up some of them in the claims review every 6 months, which was mentioned, and I'm the editor of that, and that's a good place to start. And if you want to be on the mailing list, just let us know if you're not, and we will put you on that straight away. So ITIC is a mutual insurance club, similar to what you probably heard a P&I club, but we're not a P&I club. We are a professional indemnity insurer, and we insure the ship agent for their mistakes, essentially, their errors and their omissions. And I am the claims director, so I deal with a lot of the claims. My colleague, Barney Jordan, who's actually on this event today, he is the underwriter for Sri Lanka and that region. So if any of you want to speak to him, please feel free to do so afterwards. What I would start off with is the type of claims that we see against agents. Now, I know this is about switch bills, but I just thought I'd take a couple of minutes just to mention the types of claims that we usually do see. That this can be anything from missed transshipments, it's errors and omissions. So we had a claim, these are from the last couple of weeks, essentially, where an agent was asked to carry cargo from place A to the transshipment port, where it was then supposed to go on to Hong Kong, but they missed it and sent it on to Singapore, and that resulted on a claim that the club paid out. We have claims where the agent sets the reefer temperature for the wrong temperature and the cargo is destroyed. Again, that is a claim against the agent, which the club will either help them defend if they haven't done anything wrong or pay out if they have. We have seen claims where the agents are found to apply discounts to various calls in ports. Before, that was one that we actually did a few weeks ago. That cost the agent $250,000, which again the club settled for them. And you know, lots and lots of claims like that, mistakes by the agent. But one of the questions that we get asked over and over again, and which is the reason for this talk today, is switch bills of lading, and whether you can do the switch bill, whether you're allowed to do it, whether it's legal, whether you should do it, whether you shouldn't do it. And it's advice that we give out many times, and it's something really worthwhile talking about for you guys, just so you can understand exactly what the bill of lading is, why people ask for switch bills, and if you should do that. One of the biggest problems with switch bills of lading for us as a club in terms of claims is having two sets of bills of lading out there in existence. That's one of the main reasons that claims are made. And what I thought I'd do before Alexander takes us through the more technical side of it is just mention a claim that we've dealt with here, a very large claim actually, where two sets of bills of lading were in existence. Now, this one actually bizarrely didn't stem from a switch bill situation, but the outcome was the same because there were two sets of bills in existence. So in this particular claim, a ship agent based in South Africa was asked to prepare the documents for a cargo of copper that was being sent from South Africa to China, and they produced the correct bill of lading as they should have done. But unfortunately, there was a fraudster acting within that ship agency, and they then produced a second set of bills of lading with a fraudulent consignee on that bill. And because the fraudster in this case actually worked for the ship agent, the fake bill was pretty much identical, because in all intents and purposes it was a real bill of lading. Now, when the cargo arrived in China, sadly the fake fraudster consignee turned up first with his bill of lading, and he gave that bill of lading to the local agent in China, who looked at it, everything looked to be fine, and they issued a delivery order. The fraudster then took that delivery order and went down to the customs, who looked at everything and stamped what they needed to stamp. Now, whilst this was happening, the real consignee turned up with their bill of lading. This was again because there was two bills of lading in circulation, and presented the real bill of lading to the local agent. Now, luckily, this was a quick thinking agent, and they realized that they had seen this cargo before. And what they did is what you should all do, is they contacted the carrier and said, what should we do here to protect ourselves? And the carrier said, do not release that cargo to anybody. And that's what happened. They kept it locked up in the carrier's secure yard that they had in the port. And what happened is the carrier then went to the court in China and said, look, this is the problem, Chinese court. We've got two bills of lading. We think one is a fake and one is real, but we're not sure which one we should give the cargo to, and we need the court to tell us. So the court looked at the documents and said, well, clearly this is the real bill of lading, because obviously they could look back and they could see through the payment documents who was the correct party, and this is the fake bill of lading. So we hereby order you, carrier, to give the release the cargo to party A, because they are the correct party. They then tried to do that, but the Chinese customs wouldn't comply, because they said, we're sorry, but we've already stamped the other document and we can't unstamp it and stamp the new one until we have the old one back to us. At which point they were told that the old one, document B, is in the hands of a fraudster and they're not going to give it back. To which point the customs in China said, well, in that case, there's nothing we can do. Our hands are tied. Now, what happened then is the shipper couldn't deliver, or the consignee couldn't collect their cargo. It was stuck. So the shipper made a claim against the carrier for delivery up of their cargo or monetary compensation in lieu of that. And the cargo was a cargo of copper, and it was worth $2 million. So they went to court in London, and they asked the carrier for either to deliver the cargo or to pay them $2 million in compensation. The carrier defended that claim, but it was unsuccessful and they lost. They then decided to appeal it and went to the Court of Appeal in London, where they again defended the claim, and again they lost the claim. And at the same time, they also tried to make recoveries from the fraudsters all around the world. What happened then is actually the cargo had gone up in value over this time, and the $2 million that they were asked to pay the shipper, the cargo had gone up to $3 million. So actually you think, well, this is not too bad. They're actually $1 million in profit here. But sadly for them, they'd spent $5 million on legal costs, which they lost. And then they decided to make this claim for the missing $5 million from their agent. And this is where, you know, this is how it can affect you guys. So the agent then brought this claim for $5 million to ITIC, and we looked at it for them, and we managed to get them off the hook, but not completely. We still had to pay about $500,000. But what happened here is, one, they actually only had cover for $1 million, so they were never going to get 5 million off them. They were restricted to the 1 million there. Secondly, we said that what the carrier had done was unreasonable. You know, they shouldn't have gone around spending $5 million worth of legal fees chasing up fraudsters, because you know, it was pretty obvious that they were not going to make any recovery. And thirdly, they were actually time barred from making the claim against the agent, because there was an agency agreement between the agent and the carrier, which said that any claim against the agent had to be brought within 1 year of the date of delivery, or the date it should have been delivered, and therefore they were well out of time. But as I say, it would have cost us a lot of money to defend it, so we made a gesture payment there. But that shows you, as agents, the potential issues of having two sets of bills of lading out there in circulation. And it also shows you that having an agency agreement, where it's possible to have an agency agreement, can actually be very helpful for you. So that's a very quick rundown of what ITIC does and what we cover and how we operate. And now I'm going to try and hand over to Alexander Sandyforth, who is a lawyer at Reed Smith that we often appoint on behalf of our members, and he has got a lot of experience with switch bills of lading, and he will talk that through with you. So Alexander, are you there?
Yes, Mark, thank you very much. Good afternoon, everyone. I hope you can see me. I have to say that very often I have problems when I'm using Teams, in that people say that my camera is sort of zoomed in to the maximum. If that's the case, I think if you click on your screens and click fit to frame or resize on the 3 dots, then I should appear in all my glory. But leaving that aside, I'm very conscious today I'm meant to be looking at this from the angle of the ship agents. I'm also going to answer the 5 questions explicitly that are on the little flyer for the session. But in order to do that, I think we need to step backwards and actually look at sort of some fundamental things about what is going on here, and legally, what does a bill of lading do? So if you look at the second slide that I've headed functions of bills of lading, you will see that I've put 3 points there. Now, those are the 3 things that effectively make bills of lading magical documents under English law, particularly point 1, because what they do is they link the sale obligation i.e. the person who's buying and selling, or the person who's buying and sold on, and you name it. And the shipping side, or what I call the carriage side, so the charter party actually physically getting the goods from A to B. And the 3 points, not in order of importance, but dare I say it, in order of utility, is that the first thing is the document of title. And what that means is, it doesn't mean that if you are the lawful holder of a bill of lading, you necessarily own the goods that it covers. But what it does mean is that you have a right to possession of those goods. And that's why the bill of lading is so valuable, because effectively it acts as a way of transferring security. Now, that doesn't always work, but it's effectively the structure on which international trade is built and has been built for many, many years. So that's the first point. The second point is that it's evidence of the terms of the contract of carriage. Now, why does that matter? Answer: because if something goes wrong, so I don't know, the goods are either lost or they're damaged, then again, what are you going to be looking to if you're the person whose goods have been lost or damaged? Answer: the ship. And you want to know the terms on which they've been carried. And then the third point, the receipt function, effectively saying that, I don't know, 200 copper anodes have been shipped in in apparent good order and condition. Now, here, in reality, when you look closely at bills of lading, they don't really say very much about the condition of the goods. That's deliberate on the part of the carrier, because it doesn't really want to make a representation. Again, market practice is such that people don't seem to challenge that. And so generally, what do you end up with on a bill? Answer: it's going to be a very short description of the goods. It will be said to be the shipper's description. It will say what they are. It will say how many there are or how much it weighs, and that's pretty much it. And the reason that I started with that is because fundamentally, when you are switching a bill of lading, what that means is that you're taking one set of bills of lading out of circulation, and you are replacing them with another set of bills of lading. And the reason that you're doing that is largely because you're trying to influence one of those three functions. So this is why you need to understand what a bill of lading does, so that you can actually work out whether it's legitimate or not for the bill of lading to be switched. And bills of lading can be switched in many, many different ways. So if we look at the next slide, what information do bills of lading often contain? You'll see that I've written 8 things that probably everyone on this call knows and sees on a daily basis far more than I do. But if we work through them, you will see why each of them is potentially relevant, and each of them may be something that someone wants to switch. And if we go through line by line, if, for example, you take the shipper, so that's the person who has put the goods on the ship, this is what I would call a sort of classic example of a switch bill of lading. So if, for example, I have sold goods to Mark, who you've just seen, and Mark is selling the same goods on to Barnaby, who's also on the call, then what Mark may want to do is he may not want Barnaby to know that Mark has bought the goods from Alexander. So what Mark might try and do is look at the bill of lading and say, well, it says Alexander Sandyforth Shipping in the shipping box. I don't want Barnaby to see that. What I want Barnaby to see in the shipping box is Mark Bratman shipping. Now, why is it that Mark might want that? Answer, it's because potentially he doesn't want Barnaby thinking, well, why do I have to deal with Mark? Why can't I go directly to Alexander? Because logically, the way that this works is if I don't know, if I'm selling the goods to Mark at $5 a ton, then if Mark is sensible, which he is, he will be looking to sell the goods for at least more than $5 a ton. So potentially Barnaby, if he comes straight to me, might get a better deal. Or I might be able to charge Barnaby a bit more than I can charge Mark. So it might be a win-win for us. So that's the sort of classic thing where people want to switch bills of lading. And very often in my experience, people think that there's nothing wrong with that. Now, the difficulty I'm afraid that I have with that as a lawyer is that if you go back to the functions of a bill of lading, the reality is that once a bill of lading has been issued, the way to think of it, or at least I like to think of it, is it's like a photograph of what's happened at a particular point in time. And although switching something like the shipper may be very innocent in the sense that all Mark is doing is trying to protect his business, it can also be done for more sinister reasons, in that let's take a current example with what's going on in Ukraine. It might actually be someone who just wants to put their name on the bill of lading because actually they've decided that they're still able to deal with an entity that perhaps from, I don't know, the UK's point of view or the US's point of view or the EU's point of view is sanctioned because of what's going on in Ukraine. So, for example, yesterday, I was reading in the paper about one of the Russian oligarchs who's been sanctioned by the West, if I can use that term. And what he's done is he's taken his yacht and parked it up in Dubai, because there he's not the subject of sanctions and Dubai won't help the West do anything there. So a yacht is obviously nothing to do with a bill of lading, but you could have the similar sort of situation where, for example, a Dubai-based company buys from a Russian company that the West wouldn't be very happy with at the moment, and he may want to change the identity of the shipper, not because he's fussed about concealing it, but because he then wants to sell it, let's say, to me in the West, and is concerned that if I see who the true shipper is, I'll say I can't buy those goods from you, or you're in breach of your contract by sourcing goods from an entity that is sanctioned from a UK perspective. So that's an example of how something that may be entirely innocent may also be incredibly sinister. And so I would say that if anyone approaches you as an agent and is asking to effectively say, oh, well, actually the shipper's this person or that person, my advice to you is proceed with extreme caution, because there might be a legitimate reason, but also there might be an illegitimate reason. And if I had to give a general statement about whether switching a bill of lading to change the identity of a shipper is legitimate or not, I'm afraid I would always say that it's illegitimate. Then we look at the consignee. Now, that again, that's unlikely to arise in practice, because if the bill of lading is made out to a named consignee, so if, for example, it says to the order of Alexander Sandyforth, and Mark Bratman is the shipper, then what you have got there is effectively a contract involving three parties. You've got the contract between the shipper and the carrier, so we'll treat the carrier as the ship at the moment. You've then got the contract between the consignee, so me, and the ship. And so if you want to switch the bill of lading in those circumstances, ultimately you need the consent of all three parties, so the shipper, the carrier, and the consignee. It's obviously a bit different if the bill of lading says in the consignee box to order, because all that means is to the shipper's order. So there, really, as long as the bill of lading hasn't been endorsed, the only people that need to consent to that are the shipper and the consignee. Sorry, the shipper and the carrier. So I've never actually seen a situation where people are trying to switch bills of lading to change the name of the consignee. I think the reason for that is if that is happening, something I would say very dodgy is probably going on, because if you're the named consignee and you want to change the name of the shipper or potentially change the name of the carrier, which can happen and people often forget about, I suspect, as I say, that things have gone wrong that you as a ship agent won't know about under the sale contract. And again, if someone approaches you saying, oh, let's change the name of the consignee in this bill of lading, I would proceed with extreme caution. And again, my advice would be that you shouldn't be agreeing to facilitate that. Because again, the reason that this all matters to you as a ship agent is not because you're a party to the bill of lading, but when things go wrong, and as Mark described at the start, with these sorts of things, very often what happens is that the cargo disappears or someone doesn't get paid. If you've helped facilitate that, then you are going to be in the firing line, particularly if they find out that you have professional indemnity insurers, because although there may be a limit to that cover, that's the sort of thing that people are going to look at, because if some sort of fraud or whatever has been perpetrated by someone, then that person is probably going to be long gone, and you're going to be one of the people that is still left around and going to be an attractive target to the person who says that they have suffered loss as a result of what has happened. The notify address, notify party, again, if someone is asking you to change that, that would be setting alarm bells ringing for me. However, under English law, that section of a bill of lading doesn't have any legal effect, in the sense that it doesn't give the person who's named there any rights under the bill of lading. So it's not like changing a consignee. So the consequences legally, if you like, may not be as significant. But again, if someone is asking you to change that, again, I would be concerned, because very often the notified party may be a bank, and obviously the bank is interested in the document of title aspect of a bill of lading and holding that. So again, it's the sort of question, well, why is someone asking for this? The ship, obviously a bill of lading says that. To me, that's the clearest example. If someone says to you, I want to change the name of the ship, unless there has been some sort of transshipment operation or the like, again, that would be a very, very odd request. And again, not something I have ever seen in practice, nor something I have seen reported in any cases around the world. But again, it's sort of, if you just step back and think about it, if someone approaches you and says, well, the goods were shipped on the Alexander S, and now I want to say the goods were shipped on the Mark B, what's going on there? Why is that happening? Has someone really made that mistake? If the answer is that it is actually a mistake, then that's fine. If it's, I don't know, correcting the name of a ship, then again, that's probably fine. But if it's saying it said this ship and now I mean this completely different ship, again, that should be raising alarm bells for me. Even if there has been a sort of transshipment process, again, you have got to be really careful with that, because what that may mean is that actually the date of issue, which I've put at 0.8 of the slide that we're looking at, may say something different. It may change. So if I load the goods on my ship today, and then 3 days later I transship them onto Mark's ship, the date of issue of the bill of lading for Mark's ship, if you like, should be different. You can't just say, well, it's the same goods, it was loaded on my ship today, therefore we can put that date in there. No, again, that's a big problem. Answer, why is that? Well, it's when it comes to dates, the main answer is that, again, underlying all this will be someone buying and someone selling, and that contract will say that the goods have to be shipped by a particular date. And so potentially the difference between the 31st of May and the 3rd of June is very significant to the buyer. It will also likely have an impact on pricing for the goods, again, under the sale contract. So as a ship agent, you're a long way removed from that. But those sorts of issues which are significant are the reasons why you can't just go changing dates, or you can't say, oh, an extra day here doesn't matter or whatever, because, again, it's not representing the true position, and the consequences of that could be significant. And again, potentially what you are doing there, to put no finer point on it, could be that you are helping facilitate a fraud, because it may be that the seller is asking you to do or assist in that because they've missed the shipment date, and they know that if they put the true date, then the goods will not be sold and they've got a problem. Whereas if they put a false date, then the buyer may well pay for the goods. So again, very significant. The place of issue, that is really important as well, because it is likely to have a significant bearing on the contract of carriage. Now, the reason I've written carriage conventions there is that you have, and again, I'm sure you're all well aware of this, you have something called the Hague Rules, you have something called the Hague-Visby Rules, you have something called the Hamburg Rules. And generally, those are the three big conventions that govern the carrier's liability in terms of loss or damage or delay to the goods during transit. Now, there are significant differences between them. I'm not going to go into that, but fundamentally it's things like limitation of liability, so whether you can limit your liability, whether indeed you have any liability, things like time bars. Sort of the Hamburg rules are much more favourable to the person making the claim than the Hague and the Hague-Visby rules. Potentially whether they apply depends on where the bill of lading was issued. And so again, you might get people saying, well, actually, I don't know, it was issued in Dubai, but I want the bill of lading, I don't know, to say it was issued in Turkey or something like that. Again, I'm afraid that is a big no-no. And that also takes us on to point 7, because it's the same concept, that where you load and where you discharge may have a, well, not may, it will have a bearing on which carriage conventions apply. And again, with this, one of the big issues is the sort of sanctions point. It may be that, I don't know, you want to ship, or someone wants to ship a cargo to the US, and let's say the reality is that the goods, I don't know, they're coming from Venezuela, so it's an oil cargo. So that's still something that in the US eyes is not allowed at the moment. So you can see how someone might want to say, well, actually, I don't know, the loading port wasn't a particular port in Venezuela, it was a particular port in Brazil, or something like that. Again, when you say it like that, it sounds very obvious. That you shouldn't be doing it, or you shouldn't be facilitating doing it, but it does happen. And again, my experience with that is that generally in this day and age, when you're trying to change the loading port, it's what I would call sanctions busting, i.e. you're looking to cover up a trade that otherwise may well be, or indeed is, the subject to sanctions. Now, discharge ports are a bit different because here is something that I think there very are often legitimate reasons where that can happen, and that can be that under the sale contract, the buyer has the ability to nominate a range of discharge ports. So I don't know, let's say something like main Chinese ports. It's not the best phrase as far as I'm concerned, but I think there is a general consensus about what it means. And then it may be that the buyer then says, well, actually now, I don't know, I'm nominating Qingdao, and the bill of lading has got to say that. That to me, perfectly legitimate. But again, you've just got to think carefully about why is it, what is changing, why is it being changed. But something like that is probably going to be okay. Points 5 and 6 that I haven't touched on, the description of the goods and the weight, quality and condition. As I said to you, when you actually look at bills of lading, they don't really make any great representation about weight, quality and condition. Generally, all they say is shipped in apparent good order and condition, and then it says something like weight, I don't know, quality, condition unknown. That's because the ship owner basically doesn't want to give any representation. Again, I think on most levels, this is quite an easy one in the sense that what is going to be required by a bank, what is going to be required by the parties to the sale contract is what is known as a clean bill of lading. So effectively, that is one that says shipped in apparent good order and condition. You don't want something that says, I don't know, shipped covered in rust, or shipped wet, or shipped leaking, or something like that. But sometimes bills of lading can be issued that are like that. And so someone comes along and says, well, that's not really any good to me. What I will do is I will give you an indemnity to change it. Now, we'll look at indemnities in a second. But generally, again, the point is, well, if the bill of lading states the real condition of the goods and someone wants you to help issue a document that doesn't show the true condition, again, to me, step back and think, well, how would you feel if that were you? Answer, you wouldn't be very happy. Therefore, it perhaps doesn't come as a great surprise that you shouldn't be doing it, and there's no legitimate reason. There can be legitimate disputes about the condition of the goods. That is fine. Indemnities can be used in those circumstances legitimately, but again, there you're not looking at switching bills of lading. So again, for 6, it's a don't do. For point 5, the description of the goods, again, I'm afraid in my experience, if this is coming up in this day and age, the chances are that it's what I call sanctions busting. So it's, I don't know, trying to describe a cargo that perhaps isn't the subject of sanctions, when in fact the true nature of the cargo is that it is clearly subject to sanctions. So if we run through those again, just as a summary, the reason I've put them all up there is that really the only ones that I think you can really start from the point of view are legitimate requests for things to be changed is probably going to be the shipper. Is going to be the shipper in certain circumstances. The consignee is going to be a no. The notify address is going to be a no. The ship is going to be a no. The description of the goods is going to be a no. Weight, quality, condition is going to be a no. Loading and discharge ports, loading a no, discharge port potentially a yes, but dare I say it, care needed. And place and date of issue, again, going to be a no, if the idea is that you're just substituting one set of bills of lading for another. Now, again, some more points to remember that you may say, well, why do these relate to switch bills of lading? The answer is because people very often forget about how bills of lading actually work. So the first point to remind you about, please, is that you will all see and have seen and see on a daily basis bills of lading that have original stamps on them and bills of lading that have copy stamps on them. Now, for reasons that I've never really understood and probably never will in this day and age, bills of lading are issued in sets if we're dealing with hard copies. So what you will end up with very often is 3 original bills of lading and 3 copy bills of lading. So essentially you've got 6 sheets of paper. Now under English law, the copy bills of lading are worth nothing. Again, that sometimes seems to be a point of confusion, but they are literally worth nothing from a legal perspective. It's like, I don't know, Mark sending me a photo of a check and saying, here are your fees. I'm afraid it doesn't mean anything. What I need is the real check for it to be worth anything. And that's the other fun with original bills of lading, that each original ranks equally with the others, okay? And the way that you need to think of that is it's like having 3 keys to the same car. So if you own that car, you want all 3 keys. What you don't want is to only have 1 key and for me to have a key or for Mark to have a key. Because if I've got a key and I don't know, I know where you live and I walk up and I get your car, so I get the goods off the ship. The wording at point 3, which always appears in bills of lading in some form or another, sometimes it's on the front, sometimes it's on the back, effectively absolves the ship owner of responsibility in those circumstances, unless there are very extreme circumstances, i.e. the ship owner should have known about it or did know about it. The important thing there, and going back to Mark's example at the start, is that if you are switching or if you are being involved in switching bills of lading, are you actually switching the bills of lading? Because Mark's example talked of having 2 sets of bills of lading in circulation. Now, again, it sounds quite obvious, but that's a terrible, terrible sort of situation for a carrier. And it's also a terrible situation for you as an agent if you have facilitated that happening, because you haven't switched the bills. All you've done is create another set of bills of lading that are potentially different and logically will be different. Switching bills of lading means that you take 1 set of bills and you switch them with the other. So the other set effectively comes back to you, it comes back to the carrier, and those are then cancelled. You may still have problems about why have you switched, what have you changed, but at least in those circumstances, you know there is only 1 set of bills of lading in circulation now. And the reason I mention this is because, again, in my experience, very often people think, oh, I don't know, if I've got 1 original of the 3, that's all that matters. And I'm afraid under English law, that's not correct. And so as a minimum, I think the first question you have got to ask if someone says we want to change some bills of lading is, where are the originals? Who has them? And if the answer you get back is, I don't know, they're sitting with a bank or something like that, then again, because I've told you that one of the functions of the bill of lading is it's a document of title, so effectively it's a security interest in goods. Why are you being asked to help with something? Why has the bank got the bills of lading? Why can't the person give the bills of lading back to you? All these are questions that you need to be asking. If you don't, then, as I said, I'm afraid I think that if you carry on, the chances are that you're helping create a problem that could potentially mean that someone looks to claim against you. And that means you will have to talk to your insurer. And I'm sure at this point, Mark can step in. and sort of talk a bit about the insurance coverage and what is included and what's excluded, and why it's important you do and don't do certain things.
Yeah, hi Alexander, thanks for that. As I was saying at the beginning, ITIC is a professional indemnity insurer or errors and omissions insurer. So we insure the agent where the agent has made a mistake, essentially. So what wouldn't be covered is where the act was deliberate or intentional. One thing I would say for the agent is always to remember that when it comes to issuing switch bills or even thinking about switch bills, it's not your decision as the agent to do it. You should always be told to do it by your principal. So never sort of make that decision yourself, because we do know that sometimes the agent will be contacted by the shipper who will say, oh, we're the new shipper now because we, as Alexander was saying earlier, you know, I bought these goods from party A and now I'm selling them to party C, and I don't want party C to know who party A is. So can you just swap over the bills of lading? And that's a direct instruction from the shipper. Well, as an agent, you are the ship's agent and you act for the carrier. So you shouldn't be making any amendments or changes to the bills of lading unless you have proper instructions from your carrier principal to do so. And that's one of the things that we see quite often. The things that really set off alarm bells here is what Alexander had been saying, changing the dates of loading and changing the place of loading really set alarm bells off, because those things shouldn't change unless in reality they have changed. So where the cargo was loaded is where it was loaded, and if you want to put on there a different place, then that's clearly a lie. It's not true. The only time you can really change the port of loading is if that cargo has come off the vessel and been put back on it in a different place. Otherwise, you should never change the place of loading. The other thing that always sets off alarm bells for us as an insurer is changing the dates of the loading. And as Alexander said, that's a real critical thing, because as an agent, you might think, well, what difference if we put the 31st of May or the 1st of June, as he's put there, it's only a day. What difference does that make? Well, a lot of the underlying contracts of sale are based on the price on the date of loading. So if, for example, you say it was loaded on the 1st of June, when actually it was loaded on the 31st of May, and the price collapses overnight and the seller ends up getting a lot less money, they're not going to be very happy, and usually changing the date is a fraud, or they won't pay out unless the cargo was loaded by a certain date. And obviously as an agent you should know that, you know, if the loading finishes at 5 past midnight, then the loading date is the date on which it finished, not even though 95% of it may have been done the day before. So be careful about that. Usually as an agent, when you're getting pressurized to do something, it's usually for a bad reason, not a good one. So always resist when you think that there's a problem. The one that we see most often is the change of shipper. That seems to be quite a regular thing, and I say the main, and whether we would cover an issue from this again depends on why it's being done and what you've done. So if it's a legitimate request and it is purely that, you know, the new owner wants to set it on and they don't want the buyer to know who they bought it from, that's legitimate and that's fine. And if you make a mistake as an agent doing that, that sort of thing would be covered. If, on the other hand, it was to get around sanctions because actually the original shipper is a Russian entity, and you know that those goods are coming into the UK or to the US or somewhere where there's sanctions in place, and therefore you deliberately put the shipper as a non-sanctioned Russian entity just to get around that, as Alexander was saying, sanction busting, then that wouldn't be a covered matter, because that would be a deliberate mistake or a deliberate act, sorry, on your part. It wouldn't actually be a mistake. So as an insurer, what we're looking for is mistakes rather than deliberate actions. And then I think Alexander's going to talk a little bit about letters of indemnity, because that's one thing that we also get asked about a lot. And usually the carrier or the shipper or some party will say to the agent, please do what we're asking you to do, and don't worry about anything, because we'll cover you if it all goes wrong. We'll sort it out. It's not a problem. Here's a letter from us saying that we'll cover it. You know, if anything goes wrong, if you suffer any losses from doing what we say, here's a letter that says, you know, we'll pay you back or reimburse you or cover the cost. And there's certain problems with those, and I'll let I can see that that's the next slide coming up, so I'll let Alexander talk about those in a bit more detail. But that's where we stand as the insurer. It has to be an error or a mistake on your part, not a deliberate act.
Thank you, Mark. So yeah, just to pick up a few points on the why switch bills of lading as well. As you probably worked out, the idea with this slide is that it's meant to match up with the slide about what information the bills of lading often contain. And these were pretty much all the reasons I could think of about why things could happen. So just to pick up on the points we haven't covered, point 2, selling the cargo covered by one bill of lading to several buyers. That's very common in the grain trade, in my experience, where someone big will ship, I don't know, 55,000 metric tons of grain or whatever, and then they will sell 10 parcels to 10 different receivers. Again, that to me, if you want to switch the bill of lading, so effectively you're changing the number down, so you end up with, I don't know, 10 sets of bills of lading for each receiver. That to me is a legitimate use for switching bills of lading. But again, you've got to make sure, one, if you're involved in that, have you got all the original bills of lading, i.e. the set of 3? And really all you're changing there is the amount. You're not doing anything you shouldn't, so you're not over sort of writing the amount or underwriting the amount. Topping up cargo is quite an interesting one, actually, because that can give rise to problems. Let's say the goods, I don't know, they load at a port in the UK and then they proceed to another port in the UK to load the last bit because, I don't know, the terminal had run out or something. What you should actually end up with there, strictly speaking, is 2 bills of lading. One for each loading. Now, in practice, that will present a problem under a sale contract, I imagine. And so what do people very often do? They think, oh, well, I can just issue a bill of lading, sort of saying, I don't know, 55,000 metric tons loaded at the last discharge port. Again, there, you just got to step back and think, well, does that actually represent the true position? And the answer is no, it doesn't. And so what I think you have to do in those circumstances, if you want one bill of lading, is there's actually got to be a proper description saying X amount loaded here, Y amount loaded there on the following dates. And again, the fun with that is that banks will look at that and go, that looks a bit different from what I see on a daily basis, so it doesn't work. So again, there will be pressure on the shipper to effectively get a bill of lading that doesn't say any of that. A well-advised carrier should be alive to it, particularly if they're talking to their protection and indemnity club. But again, you as ship agents, as Mark said, you're working for the ship. If you're asked to do something like that and it doesn't smell right, then again, that should be setting alarm bells ringing. In the same way with commingling cargo, again, to me, that's sort of the modern way of sanctions busting, in my experience, that you have a large amount of a cargo that's sanctioned and then you have a small amount of a cargo that isn't. You mix them together, hey presto, what does someone then want to say? Oh, it's a non-sanctioned cargo. Again, I'm afraid that's a no-no. If the bills of lading are lost, the reason I've put that up there is, again, sometimes people think that as about switching bills of lading, but if the bills of lading are lost, that's not really what you're being asked to do. And you've got to be very careful in those circumstances, because lost may mean that you don't know where they are, but it may mean that someone that's naughty is holding them. And so you've got to make sure that you protect your position in those circumstances. And one of the ways that you might do that is with a letter of indemnity that we're coming on to now. But there may also be local law things that you can do. For example, getting a court order to confirm that those bills of lading are lost and are sort of null and of no effect. Letters of credit, which was the last thing. Again, it's a sale contract issue. Again, it's something that you're not going to be privy to, but what it can mean is that basically there may be two letters of credit, so effectively two promises from banks to pay, and they may be different, and so it may mean that the bills of lading have got to be different. Again, really you have to go back to the things we thought about and look at what is it you're being asked to assist in changing, and if it's one of the red flags, which more often than not is the case, I'm afraid, with switch bills of lading, then again you shouldn't be doing it, because in those circumstances, in this day and age, one of the things that I have seen change over the last 10 years is the willingness of banks to go after people, where they're the ones that have been out of the money, or the fraud's been perpetuated on them. And again, in my experience, I'm afraid they will look at anyone and anyone that they can to try and recover their money. And if you as an agent have helped in defrauding them, even if unwittingly, for want of a better phrase, they are going to have you as an agent very firmly in your in their sights, I'm afraid. So letters of indemnity. Now, again, I think there's very often a lot of confusion about letters of indemnity, or they get grossly oversimplified, and people obviously often think, I've got an indemnity, it doesn't matter. So the first point I want to make very clear, please, is that you can't forget about everything Mark and I have just spent sort of the last hour saying, because you've got a letter of indemnity. I'm afraid it is not that simple. What I have tried to do on the slide is put up 5 points, or maybe 4 points, that you need to keep in mind as an agent. The first one is that there is no overarching standard wording for an indemnity. I know that the International Group of Protection and Indemnity Clubs produce indemnity wordings for things like changes in discharge ports, or splitting bills of lading. So that's really what I'm talking about when you've got the one bill and all of a sudden you need 5 bills of lading for smaller amounts of the cargo. That's fine. Those documents, personally, from my view, are far from perfect, and you do seem to, at the moment, be getting sort of a case with reasonable regularity on the construction of those documents. But the thing that you have got to remember is that they are not blank checks. So it's not the case that if a nice ship owner comes along and says, ship agent, do this for me, don't worry about it, I've got your back, here's a letter of indemnity. That does not mean, and I repeat, does not mean that you can just do it, you forget about everything, and if something goes wrong, you just ring up the ship owner and say, I did this for you, it's gone wrong, pay me my money. The reason for that can be numerous. The first one is that the ship owner, although he may have the appearance of being fantastic and having lots of money, may not actually have any money. Before I joined this call, and this was the reason I was a bit later than planned, I was talking to someone, albeit in a completely different context, about a similar document, nothing to do with switch bills of lading, where their company has accepted it, they've got a claim, they haven't done anything wrong, but lo and behold, the company that's given them the indemnity has no assets. So basically it's a paper company from a particular jurisdiction. So they've got a document that's enforceable, they would get a court judgment or an arbitration award saying they're owed lots of money, but can they actually turn that into cold hard cash in the bank? Answer, it seems not. Again, a lot of these things, I'm sure you'll be sitting there thinking, God, all Alexander does is state the obvious for hours on end. That's true. You would be surprised how many times I see this with companies that have taken these documents that are actually worth fabulous sums of money, and no one seems to have asked the question, who's giving it, do they have any money, and where are they based? The latter, of course, being an enforcement point. So again, to me, though, number 3 are the 3 questions that you should ask yourself. Number 4, again, this comes as a shock to people, but once I explain it, I think it sort of makes perfect sense. We've looked at today about reasons why switching bills of lading may be legitimate. And we've also looked, and dare I say it, there are more reasons why switching bills of lading may not be legitimate. And the problem with indemnities is that they only work in principle in the first case. So if, for example, someone comes to you and says, right, we need to sort this. I now need 5 bills of lading for 5,000 metric tons rather than 1 bill of lading for 25,000 metric tons. Having an indemnity in those circumstances, in principle, that's going to be fine. That's going to work. However, if the person comes to you and says, yeah, I know this bill of lading says loaded in Iran or loaded in Venezuela or loaded in Russia, but actually what we're going to do is we're going to put loaded in Dubai or something like that. Here's an indemnity. Don't worry, I'm an amazing Russian state-owned entity or whatever. You will always be able to enforce against me. You're going to have a problem there, I'm afraid. And that problem is that English law effectively will not allow you to enforce an indemnity in circumstances where what is going on is not legitimate, is how I put it. If you want the blunter version, it's where what is going on is fraud. And so you can have situations where people have been innocently duped into helping with things, and I emphasize the innocent. They've been given an indemnity, it's all gone wrong. The fraud or whatever has come out. The person has looked to the indemnity and said, look, I was just acting in good faith. I wasn't doing anything wrong here. I haven't stood to profit from this, etc. I want to enforce this. And the courts have said, no, you cannot do so. And again, obviously, that's a problem if the person that suffered the loss is coming after you because you're the one with money or you're the one with insurance, because you can bet your bottom dollar that the fraudster is long gone. And so in those circumstances, the indemnity is worthless. So that's why you've always got to do this sort of 2-step thing. Namely, is what I'm being asked to do legitimate? If I'm satisfied the answer is yes, then okay. Then we can move on to the indemnity. But if the answer to the first question is no, it's not, then I'm afraid you can't make it better by accepting or asking for or being offered a letter of indemnity, because it will be unenforceable, I'm afraid, and therefore is worthless. The final point on that slide, again, is just because, again, when people switch bills of lading, this seems to happen more often than I can imagine. Where are the original bills of lading? That's not a typographical error. It's where is the first set. Again, you'd be surprised about how many people forget about that or don't understand. I remember a couple of years ago, I did a lecture to a bank about bills of lading, and I said to them, do you have all 3? And they said, no, we only keep one, we don't care about the other 2. I told them my car story, and at which point they were all looking quite agitated about it sort of being the 3 keys that all work in the same way. Again, that's the other question that I think you've got to ask yourself here is, can you get the original bills of lading back? Where are they? And if the answer to that is no, then again, to my mind, that's something that has got to put you as an agent on high alert, that if you're being asked to effectively help put a second set of bills of lading into circulation, so that's effectively 6 keys to a car that all rank equally and all work equally well. Again, is that something you want to be doing? Answer no. But again, in my experience, seems to happen more often than not. And again, if the person that's asking for your assistance can't tell you where the originals are, or they can't get them back or something like that, then to me that is a big red flag about why ultimately you should be saying no. Subject to any questions, I'm afraid because of the way Reed Smith works, if you're interested, there's a sort of map with some dots on. And then also, I was quite pleased with this because it's the first time I've ever managed to do it. And I'm just looking on my screen. Those pictures with a sort of dinosaur in the middle, I think that's what it's meant to be. If you want to learn more about ITIC, so the International Transport Intermediaries Club, which is where Mark's from, or Reed Smith, which is where I'm from, then I think you can point your phones at that, and hopefully they should link to the websites and nothing more sinister. Thank you very much.
Thank you very much, Alexander. So we are moving on to the questions. We have 2 questions posted so far.
Okay.
I think the first question is whether we can switch bill of ladings at the final destination.
Right. So what? I know it's not very helpful to answer a question with a question, but when you're switching, what is it that you're changing? I don't know if the person wants to answer that, but in principle, again, I would say if the goods have got from A to B, and someone's saying we now want to switch the bill of lading, my instinctive reaction is why? What is it that you want to change?
I think if the person who posted, okay, say shipper's name.
Yeah, so there. I'm afraid in principle my starting point would be a no, you shouldn't be doing that, because that smacks to me of the sort of the traditional case that it's the shipper, or it's someone who wants to represent that they were the original shipper, i.e. they were the person that loaded the goods in I don't know, Singapore, and shipped them to Australia, when in fact they bought the goods from the person who loaded them in Singapore and shipped them to Australia. So I would say that's a no from my perspective. But equally, I'm conscious that goes on a lot.
Thank you, Alexander. I would like to now raise a question to Mr. Hassan from Sri Lanka Customs. Mr. Hassan, we have been made to understand that Sri Lanka Customs consider switch BLs as illegal. Can you elaborate on this by standing by Customs?
Yeah, we don't say that switch BL per se is illegal. For legitimate transaction, where comes with clean hand in a transparent manner to do the international business or trading, we consider that as a legitimate, and we allow them to do the necessary amendments or changes to switch the bill here. But we have some issues, as the previous speaker mentioned several instances where you can switch the BL. One is commingling, or you change the port of loading. If you change the port of loading on a date, as an agent, you are required to report the manifest along with the bill of lading in terms of the Custom Ordinance section 28 and 29, which requires to make a full and disclosure in that. If you don't do it and it's an offense, and liable for forfeiture. Once it is reported as the final destination, there is no reason to switch that BL. If you want to switch the BL before it's discharged in the port of Colombo or any port in Sri Lanka, the request has to be made to the shipper that this has to be switched to another destination or another port. For those reasons, we allow. Sometimes when the request is made, already you may have reported to customs when certain penal consequences follow. For an example, if it is a licensed item, restricted items, moment it is reported, if it has been imported by the consignee without a license, then that's an automatic forfeiture in terms of Section 43 of the Custom Ordinance. Then it becomes a Crown property. The question is, once it becomes a Crown property, can the agent or the shipper make a request to switch such BL to overcome such forfeiture? So therefore, legitimate reasons with a clean intention of transferring this to the interest of trade to suppress the shipper's name and to insert the buyer as a seller to another consignee, yes, we consider, but all we consider on a case by case. I think I would have answered your question fully. Do you need any clarification on that?
Thank you, Mr. Hassan. Also, my second question to you, Mr. Hassan. How will customs react when a customs declaration is done 72 hours pre-loading declaration with a port of loading or port of discharge, which won't be the same when shipment arrives at the port of discharge under a switch BL?
Yes. Now, we have two provisions applicable in terms of reporting the vessel. When you want to make a declaration prior to 72 hours, which the ship has not arrived to the Sri Lankan jurisdiction. So therefore, if they make a request, you can consider if it is a legal request, or if it is an ulterior motive, you can investigate and see whether it is for some other reason. You can inform customs and get the permission of the customs, then you can do it. Once the ships arrive and you report to customs and manifest, then there is a difficulty of switching the BL because it has shown the final destination as Colombo and you have reported to customs, it has gone into the system. So request may be some other reason, which maybe we do not know or you may not know. They may have some other reasons to overcome some disabilities of clearing the cargo. So in that instance, customs will not consider of switching such BL, but you can make a request for any amendment to reship or any listing for some mistake or made negligently by oversight. So those things can be considered on a case by case.
Thank you, Mr. Hassan. Mr. Hassan, in addition to that, is there anything that you would like to add?
Yes. Now, my advice would be to all the shipping lines prior to you consider this request from the consignees here or shipper to switch the BL. You have to get the reasons why they do wanted to do it. Sometimes customs may have seized the cargo, right, for investigation purposes. In such a situation, if you consider that and issue a switch BL without consulting the customs authorities here, you may have ended up in a big trouble by aiding and abetting for a fraud, customs fraud. So my advice would be any request, even for export from Sri Lanka, once it is loaded to switch the BL, better to inform customs that consignee has made this request, whether customs can consent this BL to be switched. Because sometimes they shift one item, giving a description to customs. Shipping lines or agents won't compare the custom declaration in order to issue the bill of lading. The ship bill of lading, sometimes description may be different to custom declaration. For an example, if you want to ship some high value cargo, high tax cargo or excisable item to another destination, you may change the description to fetch the lower rate of duty, to deceive another customs jurisdiction to pay the lower rate of duty and take it without any issues. Recently, we had an issue like that. Consignment was exported to name consignment is 0, and that has been declared as T, whereas our investigator officer found those are cigarettes. So DL is changed. So agent is responsible for customs for reporting export cargo manifest. So once you report it, then you won't be able to answer customs because you have not got the last port or the port of loading survey reports in order to issue. I don't know whether the practically that is happening here, but when you are taking the cargo on board, it is the captain's duty to make full disclosure to customs, the manifest, the cargo, and description, master numbers, everything, full disclosure. So on the customs point of view, if anything not reported or it is false, there is a criminal liability and consequences are follows. So always consult customs prior to such request. Thank you.
Thank you, Mr. Hassan. Can I now raise a question to Mr. Bratman? Mr. Bratman, you mentioned on your first example about a fraudulent BL, which is identical to the original one with a fake consignee. So if a BL is switched at some point, will it say that it is a switched BL or will it look like a normal BL?
Hi, sorry, I can't turn my camera on for some reason at the moment.
No problem.
Oh, there it is. I think. Oh no, hang on. No, it doesn't matter. You can hear me anyway. Is that right?
Yes.
Yeah. So usually when there is a switch bill, it won't look any different from the normal bill because, as we were saying, the originals are all or should all be brought in. They're essentially destroyed, and then the new ones are given out. So it shouldn't look any different to the original. So it is always difficult for any other party to know. It doesn't sort of say anywhere on them, this is a switch bill or anything like that. I noticed that there were some questions on the side about whether you can issue a switch bill from the port of discharge. I think, not that I'm too expert on it, and I'm sure Alexander will correct me if I'm wrong, but I don't think it makes any difference where the bill is created as such, as long as what's in it is correct and you're doing what you're supposed to do. So, for example, if there is a legitimate reason to issue a switched set of bills at the port of discharge, then if you're asked to do that by your carrier principal and you have got in all the original bills and you have destroyed those and you are now creating a new set of bills, that should be fine. It doesn't matter where you are based in the world. But what you should do is where the place of issue is should be mentioned on the bill. So the place of loading is different from the place of issue, and they don't have to be the same. So if the original bill of lading, for example, was issued in Singapore and the cargo was loaded in Singapore, the new switch bill should say the cargo was loaded in Singapore, but the bill was issued in wherever you happen to be, so Sri Lanka or wherever you are. And the reason why the place of issue has got meaning a lot of the time is because it can bring in different regimes like the Hague-Visby rules and conventions like that are part of it. But I'm sure Alexander will jump in if I've said anything that he doesn't agree with there.
No, I completely agree with that, Mark. I mean, again, dare I say, with more modern bills of lading, they do have the sort of the port of loading, place of issue. Some bills of lading don't have anywhere to put the place of issue, and as you say, it's the port of loading that's potentially key to the application of the Hague or the Hague-Visby or the Hamburg rules.
Absolutely. And one other thing just to mention, which again, we're not too expert on, but it's something that we've been looking at recently for other people, is the digitalization of bills of lading. So one of the issues throughout history and why they haven't gone over to digitalization quicker is, one, it is mainly that English law, well, as far as English law is concerned, English law has never allowed or never recognised a bill of lading as being something that could be possessed by a person, which is, if we go back to what Alexander was saying right at the beginning, it has those three functions. And the first function is that it's a document of title. And in order for it to be a document of title, someone has to be able to have possession of it. And now with this new blockchain technology that's coming up, the law is that they're trying to change the law to recognise that a digital bill of lading can be recognised as you can have possession of it, and therefore it can be a document of title. And the only reason I mention that is when bills of lading are digitalised, it's going to be much easier, or it should be much easier, to do these bills of lading, because in order to get all the bills of lading in, that's usually the problem, because a lot of the time the switch bills, there'll be someone will be saying, oh, the bills are lost and we don't know where they are, and that's why we need a new set, etc. So when they're all digital and online, it should potentially be more helpful to the agent, but you never know. This is pretty new technology, so I'm sure there'll be other problems as well. But I thought it's something I just mentioned because I was at a talk on it last week, in fact.
Yeah, I mean that just to add to that, I mean I think sort of this is a really positive development, because going back to the original question, it was does the switch bill of lading look any different to the former bill of lading, if I can call it that? And the answer is, other than the change that's been made, no. So you never get a document that says this document is a switch bill of lading, and bills of lading are incredibly easy to forge. I think. I mean, I could print 2 out now, and as long as I don't do anything silly and sort of I make sure I get the facts right, I could literally have filled them in while I've been talking to you, and to say which one's genuine and which one's not is not easy. So sort of hopefully blockchain and things like that will make that much more difficult to achieve. And I suppose the other thing we should say, Mark, is because I'm conscious some people may already be using things like that, you haven't got to worry that your bill of lading's not effective in the sense of it being a document of title, because if you're using one of the platforms that already exists, then effectively you're entering into a tripartite contract. So you're solving that matter as a matter of contract rather than as a matter of common law, is how I put it.
Excellent. Thanks, Alexander. At the same time, if you can tell us how many times we can switch a particular BL. I think this question is raised by Chintaka. Okay.
So, well, there's no limit. I suppose that, again, though, the question I would be asking is, what are you? I don't know, if you switched it once, why are you switching it again? Why are you switching it again? Why are you switching it again? Now, actually, with something like a change in discharge ports, that might be the sort of thing where you go through a number of switches. But if it's, I don't know, we're switching a bill of lading to change the name of the shipper, then we're switching a bill of lading to change the discharge port, then we're switching a bill of lading for the date of issue. If requests like that are coming, I'm afraid I think something's going on that shouldn't be.
Yeah, and I would echo the same. There's no limit for legitimate reasons. You can switch the bills as many times as you're requested to do so by your principal, but if it's more than once or twice, then you've got to start thinking to yourself, what's going on here? There's probably some underlying issue. But ultimately, you can do it as many times as is needed, as long as it's for a legitimate reason.
Yep. And obviously make sure again there, if you are doing that, that if you are getting a letter of indemnity, that the indemnity is amended and or replaced to respond to the further changes.
Right, thank you. Chintaka, I think that answered your question. You also have another question. What's the BL type that we can issue after switching the BL?
So
Yeah.
do you what do you mean by bill of lading type? Do you mean something like a congen bill?
Chintaka, if you are here, you can maybe answer to this. Okay, until he gets back, we will move on to another question.
Okay.
There's a question from Melinda.
Yes, that's what I'm trying to get into now, Sanoma. So when issuing the switch BL, can you not indicate the place of origin? Remove the place of origin totally.
You should certainly be indicating the place of origin, because I would be surprised if a bill of lading that didn't have the origin of goods would be any use under a letter of credit or the sale contract. If you've got a bill of lading that, let's say, I don't know, origin Iran, and you're being asked to switch it for a bill of lading that just doesn't say anything about origin, then again there, I'm afraid that's going to be a no, unless there is a legitimate reason for doing so, and I can't think that there would be off the top of my head. So you can't, if you like, switch a bill of lading with a view to omitting information that's already been given.
Yeah, you can't change the facts on the bill. So if the port of loading was X, then you can't change the port of loading to Y if that's not true. The only time you can do that is if you've literally taken the cargo off that vessel and then reloaded them onto another vessel, and then the new switch bill can say the new port of loading is whatever port that was. Sometimes when it comes to the country of origin, sometimes it says it on the bill, sometimes it doesn't. So you just have to see what the bills say, but you can't change something that's factual. So if the country of origin is Iran, you can't change the country of origin to a different country, because that's the country that it originated from.
I want to add on the custom point of view, changing the origin, because we have free trade agreements, the preferential rate of duty. So the moment you change, then there will be an issue for customs to determine the actual tariff for that particular cargo. From free trade agreement country, for example, if it is from India or Bangkok agreement countries, if the goods are shipped non-agreement countries, then we will have an issue. So I don't think that you can change the port of origin, the origin port.
Yeah, I would completely agree with that, and but also what I'm saying is you can't, if you like, on the new bill of lading, say nothing about the port of origin, and if you like, achieve the same thing by omission. That won't work either, I'm afraid.
So our next question is from Lankika. The SOB date on the switch BL should be the date of cargo loaded at port of origin or the date of cargo loaded at switch point?
Sorry, I didn't hear the first part of the question there.
The SOB date on switch BL should be the date of cargo loaded at port of origin or the date of cargo loaded at switch point?
So by SOB, I assume you mean shipped on board. The answer to
Yes.
that is that date has got to be the date on which all the cargo covered by the bill of lading was loaded. So if, for example, you load half the cargo today, and then you load nothing for 2 days, and then you load the other half of the cargo on the 2nd of June or the 3rd of June, then the shipped on board date has got to be the 3rd of June. And if you then switch the bill of lading, that is still the 3rd of June is still the shipment date.
Thank you, Alexander. We have another question from Chamin. What exactly is allowed to change when issuing a switch BL according to law? I think this was explained during the presentation also, but if one of you gentlemen would like to answer this.
Okay, so I think the things that might be legitimate are the shipper, but as I hope we've made clear, you have got to be really careful with the shipper and changing it and why it's being changed. The port of discharge, and possibly the amounts, but there what I would say is you're splitting bills of lading, although you are still switching them. Those to me are the three things where there may be nothing going on. Anything else, I'm afraid, as the starting point, I would always be suspicious about, and you would have to be very careful.
Right, thank you. This question is to Mr. Hassan. Mr. Hassan, we have a question. What would be the common legitimate reason for switching accepted by the customs and local authorities?
For example, if you want to suppress the name of your supplier or buyer and you want to raise your invoice to your buyer, then you can switch that. You can issue your invoice, you can have your profit margin, and you can do it. That is one of the legitimate reasons where you can switch the BL. And also, if you have a smaller parcels and you want to make it as a one parcel for several buyers as a one BL, then you can switch it. That is another reason where you can request for a switch BL.
Right, thank you. We have another question from Thomas. Mr. Hassan might be able to answer this. So he says, while cargo is on water and not reached the destination, can the switch BL be done without consulting the switch destination customs?
I'll give an example. Now, not only BL is BL is the document for customs. There are several other documents related to those transactions. For example, if you want to import a car, then you have to open a letter of credit. It can be imported by way of a letter of credit only. So if a buyer wants to switch that BL, then there will be an issue of payment terms. So that violates the regulation imposed by the import and export controller. Other than non-restricted items, while it's on board before reach the destination, you can switch the BL. But again, the payment terms has to be approved by the import and export controller, and they have to allow because there are funds transferred out of the country. So the person make a request as to give a reason why he wanted to switch that BL, then he has to get the money back into the country. It's a foreign exchange. So legitimate reason, they can state, this is the reason I wanted to switch this BL, then they will consider that also then again case by case.
Thank you, Mr. Hassan. We have another question. So it's allowed to switch the shipper's name, but can you advise valid circumstances to change the shipper? I think, Alexander, if you can take this question. It is also allowed to switch the shipper's name, but can you advise valid circumstances to change the shipper?
Off the top of my head, I think valid circumstances can really only be where the person who's getting the documents knows that sort of, dare I say it, the physical shipper, if you like, what was in fact someone else, and the reason for that is that I think you always ultimately, even if you're not doing it for an illegitimate reason, you always come up against the problem that at some point these goods are going to go through customs and they're not representing who actually shipped them. So it goes on. I know it goes on, and very often I know it goes on without disputes arising. But can I sit here and say that because of that it's valid? I'm afraid my answer to that is no.
Thanks, Alexander.
Mark, I don't know if whether you've seen more examples of that where it hasn't caused a problem.
No, I mean,
whether you can think of anything.
Yeah, I mean, where it doesn't cause a problem, luckily we don't see it, because we only tend to see where there is an issue. But changing the shipper is one of the most common requests that we see, and I think it is the one that goes ahead the most. And as Alexander was saying, the usual reason is because there's just a chain of people and it's been on-sold numerous times, and the new person wants to put their name on it to protect their commercial interests, essentially. And that's the reason it's done. And I tend not to see any issues from it, but that isn't to say that there wouldn't be, and that customs wouldn't say, hang on a minute, this was shipped by party A and these documents are talking about party B, what's happened? But as long as there's the backing documents to show that party B purchased them from party A and they're now the shipper, it should be okay. But we can't give any guarantees for that. We're not customs experts here.
Right, thank you. In the interest of time, I will take two more questions. We have a question from Mahesh. What is the legitimate validity of the LOI issued for Swiss beer?
Sorry, what is the validity date? Did I hear that correctly? I'm sorry, again, you're cutting out there,
LOI,
I'm afraid.
yeah.
Sorry, can you just repeat the question for me?
What is the legitimate validity of the LOI issued for Swiss beer?
So with the LOI, if you're doing something genuine, as it were, then the LOI will be valid, and as far as I'm concerned, you don't need to worry about things like time bars and the like, because the claim will appear long before that happens. As soon as you're getting into the not doing something valid or something that may be slightly dodgy, if I can put it that way, rather than outright sort of misrepresenting the position to try and sort of defraud someone, then as soon as you get there, I'm afraid you're on shaky ground about whether the LOI will ever respond to that sort of claim. And so that's why you've got to stop and ask what it is you're being asked to do, and whether you think there is a sinister reason behind that. And if there is, then I think you should work on the basis that any LOI will be unenforceable. And so effectively you're proceeding at your own risk in those circumstances.
Thanks, Alexander. I think Chandima wants Mr. Hassan to elaborate on the question. Mr. Hassan, would you be able to help us here? Yes.
The question is whether seller can change the shipper's name. Yes, you can do it to suppress for your buyer, because seller becomes a shipper, and for new buyer he can suppress his actual shipper's name in the switch period. That is a person that is legitimate.
Thank you, Mr. Hassan. So as the last question, we have a question from Trisha. If the seller and shipper are two different parties, and if I am the seller, and if I do not want my customer to know who is the actual shipper, is that possible to do in Switch BL?
Well, I think you've just heard from customs that
yes,
sometimes that can be possible. From my perspective, if you wanted to do that, then I think, as you say, you would have to check with customs whether they would have any issue with that, and if not, then although I still struggle with it as a matter of English law, because it's not representing the position, because the shipper is the person who puts the goods on a ship, and that's not you as the seller in this example, then that may be the situation where it happens, and sort of no one is any the wiser, as it were. In terms of how you might structure that under your sale contracts, where you're ultimately you must be buying from someone if you're the seller but you're not the shipper, so you're buying from a local producer. I think the way that you would have to look at doing that is putting some sort of wording in the bill of lading, saying effectively that you're the shipper. I'm just trying to think how you could do it. One way it might not be what you want, but sometimes you do see things like, I don't know, shipped by Alexander for and on behalf of Mark Bratman. I'm seeing that more and more in bills of lading now, so I don't know if that would work. If you don't want the if you just don't want the name of the shipper that's there, that is the true shipper, then I just don't see how you can actually deal with that beyond just switching the bill with the consequences that may follow, I'm afraid.
I would like to add a little further to that. If the buyer in Sri Lanka, if he wants to suppress his supplier or the seller when he resell that goods, then he should have the title to that goods. Then in such a situation, he can make a request to switch that BL, then that is legitimate. Customs would consider that.
Mr. Hassan, the final question is to you. Is there any penalties for open account shipments coming as switch BLs?
I am not too sure about this because there's a restriction. The recent developments or the amendments to this import controllers regulation, I'm unaware of that. So therefore, I cannot comment there's a penalty on not on that open account.
Thank you, Mr. Hassan. So, gentlemen, thank you very much for your valuable time today and the inputs. I'm sure the participants were able to get a clear understanding on switch BLs as the topic was well covered and the questions were well answered. Once again, on behalf of CASA, thank you very much for participating, and a special thanks to Mr. Bratman, Mr. Sandiford, and Mr. Hassan. Thank you very much.
Thank you.
Thank you very much.
Thank you.
Thank you.
Take care, everyone. Goodbye.
Bye-bye.
Thank you.
Thank you all.
Thank you.
Thank you very much.
Thank you all.